Welcome back to the Regent Law Podcast. On this episode, we hear from Theo Wold. At the time of filming, he was Solicitor General of Idaho. He now works as the Director of the Administrative State Project for the Claremont Institute. Enjoy.
Next, we have Theo Wold, the Solicitor General of Idaho. Thank you for joining us today.
Thanks for having me.
We're very excited to have you. Thank you for making the trip. Everything go smoothly?
You know, I've never slept on a flight in my life, except for last night, first time.
And comfortable?
Yeah, I slept like a baby.
Wonderful.
And great.
We're glad that you're here to join us. We're here for Regent University School of Law's symposium on the administrative state. And based on your experiences, we think that you might have something to say about that.
Fair assumption.
But before we get too much into that, if you wouldn't mind, could you just tell us how you came to your position and what got you there and what road you took?
I don't know how far back you want to go, but I do like to say it's kind of a paraphrase of Lincoln, who's paraphrasing Thomas Gray, the short and sample annals of the poor. I grew up in a very poor family. And in a very working class part of one of the poorer regions in the country. I did not know any lawyers growing up, none. And in fact, lawyers were not held in very high regard in my household. So I'm something of a black sheep in the family. As my dad used to say, the only kinds of scuffs and cuts on my hands were going to be paper cuts. But always had an interest in history, politics, government, and of course, debate. I was a California state debate champion, and people always, as I'm sure you know, if you like oral advocacy or argument, you should be a lawyer. And one thing led to the next. Eventually, I decided I was going to go to grad school and study political philosophy. In grad school, I learned that that was kind of a waste of time, both financially and also there's a lot of arguments about nothing. So I decided I'd go to law school. In law school, I spent probably the 3 most miserable years of my life. I thought it was pretty intellectually stultifying. I did not have a great time. But I learned that some of those early interests in the Constitution, in history, that they had an outlet, that there was actually a place for that vocationally in the practice of the law. So I clerked at the District Court of Puerto Rico and then on the D.C. Circuit for someone who was a hero of mine throughout my youth, Janice Rogers Brown, who was on the California Supreme Court, but at that point was on the D.C. Circuit. And Judge Brown, full of great advice in a whole host of ways, but one of the things she always encouraged me to consider were positions in government where you could be of use. And, I never set out to be a Solicitor General. It wasn't like a bucket list or a brass ring I was aiming for, but it is true what a lot of the Solicitors General that people are familiar with, those who argue in the Supreme Court and whatnot, it is true what they say, which is it is one of the coolest jobs in the profession. You get to do meaningful writing. You're on the cusp of a lot of really interesting cases, and you're often positioned to make sort of the first pass at a lot of arguments. Maybe not the final iteration. Maybe it's not the same as what the judge is going to lay down in an opinion, but you have an opportunity to kind of shape the law in some instances. So it's been a very circuitous journey to where I am now, but my advice always to young lawyers is if the train is coming through the depot and someone's giving you a ticket, get on and figure it out. You don't need to have a 5-year, 10-year plan. It will take you somewhere.
Seems like good advice. I appreciate you sharing that with us. It's kind of a cool thing to see the horrible experience in law school transformed into the coolest job. I also can associate with the grad school. I double majored in political science and philosophy.
Okay.
So I couldn't just pick one useless major. I had to have them both.
Double down.
So could you tell us a little bit about I mean, on a day-to-day basis, like what does a Solicitor General do for our listeners who might not know what that role entails?
Yeah, so it varies obviously state to state. I have essentially three buckets that I'm constantly monitoring. One is that I advise the Attorney General on a lot of sort of strategic litigation questions. So that's touching on departments outside of mine, natural resources or civil litigation, giving him an idea of where things may go, and in a way that is familiar to folks who have a clerk for someone like a Justice Kavanaugh. A lot of federal judges are always talking about decision trees, right? If we go this way, what are the consequences, or what's likely to happen? If we go that way, what can we expect to be the probabilities of success or potential consequences? That's that bucket. That's what I'm doing a lot. The second is one of the great parts about being a Solicitor General is that you are enmeshed in a nationwide network of Solicitors General. And every day there is a new question coming forward from a colleague or an opportunity to participate in a multi-state effort, whether it's litigation, an amici, or a cert petition. So a lot of the day is spent evaluating those requests. Is this in the best interest of the state of Idaho? Is this consistent with the philosophy or the understanding of the law that the Attorney General has articulated? And if we join this or we participate in this litigation, what are the potential repercussions for Idaho? Each state has its own equities. To give you an example of that, we joined in a suit that the state of Louisiana brought against FEMA on a recalculation of essentially flood insurance rates. And there were a lot of state agencies in Idaho that kind of scratched their head. Because if you looked at the other states that joined Louisiana, they all had one thing in common, more or less. They have coastline. And we don't. And our view was, look, we have a lot of riparian zones where we're building immense new housing projects that are in 100-year, floodplains. So this question of how, flooding or natural disasters can affect insurance prices and disaster relief, it may not be a live issue in Idaho today. There's a really strong possibility it will be tomorrow. And those are the kinds of questions that you have to be thinking through. So, and then the last sort of bucket is, the part of the job that I enjoy, which is the writing, where you're taking the research and you're putting it to use either in our own efforts that we're leading for amicus or cert petitions or our own litigation. And I often tell young lawyers, this is one of those things where if you don't know what it is you want to do, focus on building your skill set. And there is no limit to the use of good writing. And that's very true in the work that I do as Solicitor General.
Amen. Well, thank you for sharing, the three buckets that you seem to subsist in. Do you
almost like an aquarium? Yeah.
So we're here to talk a little bit about the administrative state, and I think it's become a little bit of a buzzword. A lot of times has a negative connotation with it. What, in basic terms, is the administrative state?
Yeah, and just in the way you frame that, which I think is correct, I agree with. It has become something of a buzzword, and this just shows you how late we are to the party. Is the lexicon and the terminology, I think, is evolving and appropriately so. Administrative state is the kinds of terms, the sort of encapsulation we should have used 40 years ago. I think the administrative state is the full flowering. It's the culmination of the early progressive project, which was essentially to say, as President Wilson did both when he was president of Princeton and then later president of the United States, gave voice to this explicitly. I'm obviously paraphrasing, but explicitly. You can go and look this up for yourself, kids. The idea that a constitutional republic as constructed by the framers worked for a certain day and time. but that the problems of modern governance are so complex and so sophisticated that you need to apply, as Wilson sort of distilled it, the rules of scientific objectivity to popular governance. So what does that mean in layman's terms? You got to have experts exercising the levers of government and making the determinations and decisions for the people. Your average farmer, truck driver, bricklayer, they don't understand centralized banking. This is what the progressives would say. Your average school teacher, they don't understand how you should control for pollution in waterways or in the air. Experts who have advanced degrees, who have real expertise in a certain area, they do. And the scientific objectivity is they will make decisions and implement policy not based on ideology or politics, but consistent with an objective view of what is the best outcome. So that then takes shape over the years, I think first under the progressives, obviously, but then under President Roosevelt, and just this metastasization of the federal government, the expansion of all kinds of agencies targeted on specific questions of governance, whether that's banking and finance, labor and employment, whether it's agricultural issues on subsidies or maintaining quota on grain production, all the way up through the Nixon presidency of the EPA, and through the present day with the creation of things like the CFPB. So it is essentially the idea that the federal government will govern best when it empowers neutral, objective civil bureaucrats who are possessing a certain type of expertise, when it empowers them to make the decisions that otherwise would have belonged to citizens governing themselves.
And the way that you described that just now, at first glance, might seem beneficial, right? Experts pulling the levers. At the state level, how have you seen that impact yours at Idaho, though?
Yeah, so I'll say something. I'll sort of answer to an objection that you often hear in the way that I've described the administrative state, which is, okay, so this guy, I guess, doesn't want certified pilots flying planes, has no interest in having medical licensing boards, certify physicians or surgeons. He wants, fast food workers determining what a Superfund site is. I think that's as a deeply pejorative argument, and I would be reticent to ever dismiss expertise. I'm a lawyer. We go through our own training in a level of expertise, right? And yet, I think what you will see at the state level, because it's more subtle and it's smaller scale, so it's not as detectable to the naked eye, is that there's a steady and slow erosion of the kinds of questions that are presented to everyday people for their input and their determination. To give you an example, one of the ones that's so common in the West is the determination of what to do with species conservation. And if you think about it, voters are asked to weigh in on all kinds of, and I'll use this language for a reason, moral questions. Should we legalize this type of drug? Is it right or wrong to take the life of an unborn child? And yet, questions dealing with species conservation, that's not for voters to determine. We have a cadre of individuals who are trained, expert biologists. They will develop policies, and those will be enshrined either through regulation or adopted by a legislature and put into statute. You, the citizen, don't get to determine whether or not you want gray wolves running through the forests of Idaho or grizzly bears on your front lawn. And why? Again, because that's a species of question that somehow we have delineated as being beyond the province of everyday people. And I think that's one of the most insidious aspects of the administrative state.
It seems like a particularly dangerous avenue for a slippery slope
Yes.
when you start taking questions out of the hands of the people.
Yes. Well, I mean, and the real concern, because we've been living in this system, whether people want to, acknowledge this or not, there's something I love that the political, I mean, I hesitate to call him a philosopher, but the political thinker Curtis Yarvin will say is, look, the French number their republics. They don't engage in this fiction that once the monarchy was overthrown, there's been a contiguous thread of the republic, and it's been constant and the same throughout the centuries. In America, we labor under this fiction that we are still in the framers' republic. It's the same as it was when the Constitution was adopted. That's patently false. That's fantastical. It's a lie perpetrated against the American people, because the administrative state has changed everything. The empowerment of federal agencies that can make law, essentially, through regulation, can make law, can enforce that law through civil or criminal penalty, and can interpret that law with what are called, which I think is, there's some humor in this somewhere, administrative law judges. That aspect essentially is a recreation. I think Dr. Hamburger, Philip Hamburger, who writes on the administrative state a lot, is right. It's a recreation of the monarchical system. The king issues an edict. He gets to interpret the edict, and then he gets to determine who's broken or complied with the edict. I think that entire structure, which we've been living in now for 100 years, has had one really important diminishment, which is self-governance is a reflex. You have to develop it. It has not been natural to human beings throughout time immemorial to govern themselves. That's why we call this a grand experiment, right? Can people govern themselves? And over time, as the administrative state has either supplemented or abrogated the ability of citizens to govern themselves, that capacity has been emaciated.
I think that is a really deep insight. And I want to touch on something that you mentioned, and it's the development, the progression. And I think we kind of intrinsically or implicitly know that the administrative state is growing.
Yeah.
But could you touch on some of the smaller changes that happen from administration to administration? You mentioned FDR, a big shift, but then also Nixon and some shifts there. What kind of shifts do we see today when administrations change over?
Yeah, I think the way this is most visible now is by and large, and you can hear this, you don't need a law degree. You can hear this when you listen to that absolutely absurd ritual that we continue to engage in called the State of the Union, where the president goes and stages this kabuki theater ritual before both chambers of Congress. They very rarely ask for major legislative packages anymore. The gridlock and the inability of Congress to legislate is known to most people in D.C. It is also a consequence of the delegation of legislative authority to the administrative state. So what do presidents do now? I often argue presidential power essentially exists in two forms. The ability of the president to stand on the bully pulpit through rhetoric to shape the national discourse, and two, to affix his signature to paper documents. And what are those paper documents? Regulations, executive orders, presidential memorandum. So what you see administration to administration now today is a seesaw battle between regulations. I'll give you a good example. And this is one of those sort of scary things about self-governance, as I was talking about a moment ago. A lot of people don't realize that DACA, the program that allowed minor illegal alien children to remain in the United States, Dreamers, as they're called, DACA is not a program with any statutory basis. And so people say, well, it must be a product of rulemaking. It must be a product of a regulation. No, it's not that either. DACA was created essentially on a Dear Colleague letter from then DHS Secretary Janet Napolitano, who sent a memo to the White House to her boss, President Obama, and said, look, you've got prosecutorial discretion. We've got these kids. Exercise your prosecutorial discretion and decline to enforce the Immigration and Naturalization Act against this certain segment of children. When the Trump administration came in, we looked at that and we said, okay, it's not a rule. There was no rulemaking. It's just a dear colleague letter. It's just a memo. So I guess a memo beats a memo. We'll just issue a memo and say, hey, DACA's no more. And federal courts said, no. Justice Roberts said, no. You want to get rid of DACA, you got to engage in an affirmative rulemaking process to get rid of it. That seesaw battle, another example, the Obama administration put in place their Waters of the U.S. rule, WOTUS. The Trump White House took it down. The Biden administration in February of this year announced they were reanimating the zombie rule that the Obama administration first enacted in 2015. That's what governance is going to look like. And I think for most Americans, the idea that the implication of a national election isn't a wholesale change in legislation, doesn't change the structure of statutes, but really is just a contest of memos and regulations, I think that would shock them. But that essentially is what self-governance looks like under the administrative state.
It seems exhausting, the back and forth, the reenactment, the de-enactment, makes you wonder, if it's sustainable.
Yeah, well, and I think when you look at the Federal Register where regulations are printed, just the rules of last year, someone was saying the other day, if you stack them on top of each other in printed form, they're about 18 and a half feet tall. I mean, Americans have no idea how prolific, how active the administrative state is every day in micromanaging, as some folks got a flavor of recently, everything from the kind of stove you can purchase to the kind of washing machine, what type of fuel you can put in your car, and what kind of light bulbs you can put in fixtures in your house. It is insidious in that it has something to say about every aspect of everyday human undertakings, human life in the country. And its scale and size is significant. I'll give you one last number to conceptualize this. The President of the United States, upon election, gets to appoint 4,000 presidential appointees. 4,000, an enormous number at some level. There are 4.5 million, some people will say today 5 million federal employees. 5 million. And that's not even counting subcontractors and vendors who do these sort of private-public partnerships with the federal government. The sheer size of the federal workforce alone dwarfs any meaningful political accountability.
You'd think you'd almost need an administrative agency to handle the appointment of 4,000 individuals.
Yeah, well, we have the Office of Personnel Management.
Well, there you go.
Yeah.
Problem solved.
And to run the buildings, we've got GSA, the General Services Administration, and to do the accounting. We've got the General Accounting Office. You think of it, and there's a federal agency that does it.
So obviously, there's some practicality that's required, right? Like, at some point, the president and the executive branch will need some form of enforcement, some form of power to actually enact stuff, and, they're going to need help. What's the proper role for an administrative agency? How ideally do you think that an administrative agency should be created and utilized, if at all? Well,
and getting back to this idea that crazy guy Wold believes that there should be no such thing as certified surgeons. So, let's control for that.
Anarchists.
Yeah, right. Let's control for that argument. This isn't an argument against expertise or the proper role of informed knowledge in our government. But there are potentially certain questions that are not appropriate to government. Certain things that government should not be doing. And as much as we want government to study atmospheric change, we want them to tag and record species variations among penguins in the Antarctic, potentially that's not the proper role of the federal government in a limited constitutional republic like ours. So my point being, what would be the proper sort of construction of administrative state? number one, it would actually be accountable to the chief executive. Because keep in mind, there are plenty of federal employees and those who are heads of independent agencies or certain sub-agencies in the federal government who are not fireable by the president. And I think a lot of politicians use the line today, if I can't fire you, then you don't work for me, I work for you, right? I think there's some truth to that. So they would actually be accountable to the chief executive. And two, their authority to exercise policy-making privileges would always filter through political appointees. And why? Because Americans still labor, I think, sadly, under the misapprehension that when they vote and they say, I don't like the way things are going on X, Y, and Z, and they vote for someone who says, I'm going to change X, Y, and Z, they actually expect it to change. And because of the size and scale of the administrative state, the continuity, regardless of who sits in the Oval Office, will in large part continue. And making sure that there's political accountability for those policy-making privileges that bureaucrats exercise is an extremely important part of changing that. And then the third part, finally, would be to essentially say, look, there's a time and place for expertise, but our system of government, as designed by the framers, doesn't enshrine the idea that the PhD knows more than the farmer, the truck driver, or the bricklayer. Citizens are the government in our country. This isn't an oligarchy. It's not the Ming Dynasty where the mandarins get to make policy. They can help inform the discussion, but ultimately the question should be put to the people's representatives. That's how a representative republic works. So for lawyers, to put it in legal speak, Congress needs to stop delegating so much legislative authority. It needs to actually tackle the hard questions. And the easiest way, to explain what that looks like is look at congressional enactments or statutes, and it's very general, vague on the specifics, and a designation of the Department of Commerce shall do this thing. EPA will make the waters clean. You figure it out. And that needs to change. And that might be the proper place for expertise in our government. Maybe that's, if the PhDs want to make policy, they should run for the House of Representatives.
I like that. It'd like to be an interesting turn of events, see that happen. So to step away from the federal side of things to the state side, where I think that your expertise will shine through, it seems as though we're seeing a trend of states shying away from some of the administrative state. The evidence of this is looking at some of the states that have recently rejected Chevron deference, which is something that's, I'll be candid, above my head. But it does seem as though the states are not buying into this idea of the administrative state anymore. Can you speak to that trend at all?
Yeah. So I think one thing that's really important to keep in mind is Chevron deference, which essentially says judges don't get to interpret what a regulation or a rule really means. The experts in the agencies get to. We defer to the agency's own interpretation of its rulemaking. That was actually a conservative idea. It was originally seen as a check on judicial overreach and something of a check on the growth of the administrative state.
Come on, conservatives.
It's been a giant failure. Yeah, it's been a giant failure. And you're right to point out that, and some people may not be aware of this, but every state's got their own mini administrative state. They have their own departments of transportation, their own employment bureau. They've got their own boards and commissions that exercise all kinds of regulatory power. And a part of that is a lot of states have adopted their own form of Chevron deference. Only recently have we seen a number of states, Utah, Ohio, Alabama, I believe, reject this idea of Chevron deference and say, no. It's the proper place in a tripartite system of government like ours. If the judiciary can oversee the constitutionality and the legality of statutes, they certainly can look at regulations and determine whether or not they're consistent with the state constitution, the federal constitution, or state law. And that's a sea change, and a good one. And I think we'll see that continue largely in what we call red states. But I think the age of deferring to faceless, nameless, politically unaccountable bureaucrats to run state governments is coming to an end.
We'd like to see it.
Yeah.
So what are some, and this is just to get at some of your perspectives and some of your experiences, but what are some wins that you've seen as the Solicitor General? And from your perspective, what are some wins that we've seen in the area of the administrative state?
It's a tough one because they're not always obvious wins, but I think the vaccine mandates and the pushback, and that obviously predated my tenure as the Solicitor General of Idaho, but I think that effort was an enormous success, limiting and cabining the authority, even in a stated emergency, of administrative agencies to essentially promulgate a policy and then enforce it through mandate. I think the pushback on some of the environmental regulations, and particularly in the WOTUS space, but also a lot of things dealing with natural resources, in particular in the West, I think that's an enormous success. That if it's not expressly delegated by Congress, so the clean power issues that West Virginia litigated for years, that has given rise to what we call the major questions doctrine, right? That if it's something so significant, Congress probably needs to say what the specifics are. A regulator, a bureaucrat can't just fill in the gaps. Those have been enormous victories, and those have come from the persistent, very thoughtful and deliberate litigation strategies pushed by a number of very key, again, red state solicitors general.
We like to see that trend, and hopefully it will continue. Thank you for sharing those wins. There was one last thing that I wanted to ask you before kind of go to some closing questions, and trying to remember what it was. Oh, what's one thing that you would like to see, like looking to the future? What's one thing that you hope we can see change either through momentum or something that you'd like to see momentum build on regarding the administrative state? Is there some particular area we need to be looking at?
This has application both in the state and federal government context. I think increasingly constitutional officers, so governors and state attorneys general, but also local law enforcement, need to be increasingly more skeptical of the expanded power to surveil, to investigate, and to prosecute American citizens under that suite of laws that were enacted following the September 11th attacks. The Patriot Act and its adjoining statutes and its progeny, we were promised that was never going to be used or wielded against American citizens. And a lot of folks, it's not just the Bureau, it's not just the agency, so the intelligence apparatus in the federal government, there are a lot of local law enforcement guys who love these kinds of tools. And I think it's really important for citizens to be aware of the capacity of state, local, and federal government to essentially meddle in their affairs, sometimes for nefarious reasons. And why now? Because at the time of September 11th, we were told, as libertarians, civil libertarians raised these kinds of concerns and objections, we were told again and again, well, hey, look, the technology doesn't exist to read every text message. We don't have the capacity to sift through every phone record. We do now. Machine learning, AI has expanded the reach. And so that view articulated by novelists like Bradbury or Orwell, or social reformers of the 19th century like Jeremy Bentham, his view of like the panopticon, the all-seeing eye of government, that's a reality now. Whether you think you're safe on Signal or Proton Mail, you're not. And that's incredibly dangerous, especially in a government constituted like ours, where citizens are led to believe that they are free from unwarranted search and seizure, or free from unwarranted investigation. And I think that's something we need to really cultivate as a conversation and ensure citizens are aware of the dangers that's posed by those laws.
And in closing, what you just said about awareness and being aware of what's going on around you and being informed relates back to what I star as maybe one of the most important things for the average American to be looking to, and that was I've started as make a reflex of self-governance.
Yeah.
Does that sound accurate?
Yeah, for certain. And people will often say, like, so, okay, well, what is that? Well, the beauty of our system of government is that the framers gave us very clear instructions written in plain English. You don't, we're lawyers, we are studying the law, but what the framers designed and what they wrote down is intelligible to anyone, regardless of whether they have a law degree or they're a practicing physician or they're a tech bro billionaire. It is there. And citizens really need to cultivate that interest and that vigilance, the reverence for those documents, but also the simple study of those documents. There was a time and place where that wasn't so weird to suggest that, like, hey, you know, you're the father or mother of a household, you work a 9 to 5, you got a mortgage, you got bills to pay, but there's a time and place for you to revisit the Declaration, to spend some time with the Constitution. And so on the state side, as you asked me earlier, what I've often told people is right now, take your state constitution seriously. Follow what's happening in your state legislature. What are they passing or enacting in your name? Because it's done on your behalf with your authority. And then 3, get interested in your state judiciary. The federal Article 3 judiciary has been at the forefront of national politics now for the past 50 years because essentially of one case. Meanwhile, nobody has been watching or studying or examining what state judiciaries have been doing to shape criminal law, to shape the regulatory landscape in the state, to shape the statutes that affect small businesses, the ability to build new infrastructure. So get interested in who your local district court judge is, because for a lot of Americans, those are elected positions, and they're asked to vote for them. And so we hope that will be an informed vote. So that's what the reflex of self-governance looks like. It's not hard. You don't have to go take a special course. If you wanted to, places like Hillsdale offer those. But barring that, just get yourself a pocket constitution and flip through it.
Sounds like great advice, and I really appreciate your time that you've taken to come and speak to us and give us that advice about how to be aware and how to combat the administrative state, to throw around the buzzword one more time. So thank you.
Thanks for having me.
Absolutely.